Comes from Paul Krugman, Nobel Prize winner, economist, not a lawyer. But regardless, it speaks to the attitude the left has about the rule of law, and that would necessarily include Alvin Bragg, the Manhattan DA. The headline in his op-ed in the New York Times: Trump's indictment is karmic justice regardless of the verdict. Karmic justice. See, now we have a situation in America where we use the law to mete out karmic justice, not actual justice under the rule of law.
Makes people feel good.
Big difference.
Yeah.
They're not going to feel so good when we descend into a lawlessness and when they or someone they care about or some politician they support is the subject to the same sort of arbitrary and capricious use of the law to score political points rather than to maintain a civilized society. Trump's indictment is karmic justice. Right. You can't say justice. You got to have karmic. A synonym in the context would be political. Trump's indictment is political justice. Well, that's 180 degrees from the rule of law. For more on the topic, pleased to be joined by Tom Hoagn, who served as a federal prosecutor, local prosecutor, and elected district attorney. He currently works in private practice. Tom, thanks for joining us again. Appreciate it.
Absolutely. Always a pleasure to be on. And, to be fair to Paul Krugman, he hasn't gotten anything right since he won the Nobel. So
No. Yeah, I hear what you're saying, but that opinion is representative of more than Paul Krugman.
Yeah, absolutely.
But I mean, and therein lies the problem. This is what we have playing out in real time against a former president of the United States.
Yeah, absolutely. This is a political indictment, but there's a lot of things going on here, which I suspect is what you want to talk about this morning.
Yeah. So, give us your distillation of the week that was last week and where things stand, and what advice and counsel you'd be giving Trump if he were your client.
Well, the first thing that I wanted people to do is to look at this from the standpoint of Alvin Bragg, so that they can understand what's going on in Alvin Bragg's mind as he's deciding to do this. And there are 3 points about that. The first one is everyone's saying fairly, look, this is a very weak, very hyper-technical indictment, and it's based on incredibly flawed witnesses, people like Cohen and Stormy Daniels. And all that's absolutely correct. But what people are underestimating is the fact that juries matter and judges matter. And Alvin Bragg has brought this case in Manhattan. And Trump got less than 15% of the vote in Manhattan. The jurors are going to be drawn from a pool of 85% of people who would vote to convict Donald Trump of just about anything. So juries matter. You can think of this as sort of the reverse OJ, where you bring a case matters. And I know some people have said, well, the defense lawyers will move to change the venue or change the veneer of this case to someplace else. That's not going to work. And it's not going to work because you only do that when the person is so well known in a particular place that you can change the venue, change it to a different jury, change it to a different location. But President Trump is known everywhere, so it's not going to work. So he's going to get tried in Manhattan. And he's going to get tried in front of these jurors and in front of a judge who gets elected by those same citizens who despise Trump. So he's on very, very unfavorable territory.
Yeah,
so that's the first point.
Yeah. Okay. Go on.
But that's the politics of it. The second point is there's a follow-up charge probably coming out of Atlanta, and Alvin Trump is probably looking at that one and going, "Yeah, my case may be weak, but the other case is probably stronger, and I want to be the first to charge no matter what. I want that scalp on my wall." And the third point is he's an elected politician, Alvin Bragg. Does he really care whether or not he wins or what the rule of law is here? Not really. He's responding to those same voters who are going to approve of him doing anything to attract former President Trump. So all of those things are what goes through the mind of a political prosecutor when they're looking at a case, which of course is exactly the opposite of what a prosecutor should be doing. The prosecutor should be taking the politics out of it and should be looking at it from a straightforward sense of what's the law, what are the facts, what do I need to take into consideration.
So do you think this case is actually going to go to trial? Because in the 16-page indictment, 34-count indictment, what crime was he trying to cover up?
I do think it will go to trial. The secondary criminal violation is, of course, what everybody's wondering about.
Okay.
In order to change this from a misdemeanor, just business records case into a felony case, there has to be a secondary criminal violation. In this case, people are speculating, well, maybe it's got something to do with the federal election code. Maybe it's got something to do with tax information, but Bragg hasn't identified what that secondary criminal violation is, which is a little odd because they went to the trouble of putting together a whole statement of facts to go along with the indictment to sort of flesh out what they think is going on, but they're still sitting there never having identified what the secondary violation is.
Right.
And
So
that's
if you're Trump's defense attorney, and we put this to Andy McCarthy, said, why don't you immediately file a motion to dismiss for failure to state a claim? And we put the same question to Richard Epstein, famed law professor Richard Epstein, and he said, well, I would first start with a motion to dismiss based on jurisdiction, the lack of jurisdiction, because if the second crime is campaign finance related, then state prosecutor can't enforce federal law. What about those two, either one or both of those plays?
With all due deference to Professor Epstein, that jurisdictional motion is not going anywhere because the primary violation is in New York. The secondary violation won't matter for jurisdictional purposes.
What about failure to state a claim?
Failure to state a claim, you could bring that and force them to identify what the secondary violation is, and they should do that. They should force the Manhattan DA's office hands in order to identify what that secondary violation is, because it sounds like they're not really quite sure. They haven't fully identified it yet, so you better make them choose it so that you can start to respond to it.
Well,
the judge would say, yes, you
Yeah.
have to identify what the secondary violation is so the defense can start to prepare for it.
I mean, isn't that an incredible statement? You're charging a former president of the United States, and you don't include with specificity the charges, that second charge, and if you're right, they're not sure what it is yet. I mean, just when you think it couldn't be more patently political and absurd, if that explanation is actually reflective of the thinking going on by Harvard Law grad Alvin Bragg, then Harvard Law should be shut down by the Bar Association.
Well, there may be a lot of reasons they want to shut down Harvard Law.
Yeah, well, fair point.
But if you're going to go at hyper-technical violations against every former public official, let me tell you, the confidential documents thing that they keep bringing up about former President Trump, they would also have to charge current President Biden. They would also have to go back and charge every president and actually every elected official who's ever handled classified documents, because I was an elected official. When I went to leave office, there were classified documents I had. I actually went through an extra step of realizing that so many people had this problem that I actually got mine officially cleared. But let me tell you, I've run into plenty of elected officials who have not, who 20 years after they were in office look around and realize, hey, I've got top secret stuff here. But if we're going to turn around and start attacking all of our former elected officials once they're out of office, we're going to become a third world country where you go directly from the presidency to being charged with something ridiculous over and over again, because you can always do that.
You mentioned the Atlanta case, the Fulton County case for, allegedly it's obstruction of justice, election interference case. But there again, sort of like what we've got here, you essentially have exculpatory evidence on the very call with the Secretary of State, Raffensperger, that is supposed to be the evidence of tampering, the evidence of obstructing justice. And by the way, that call was also, parties to that call were two seasoned election attorneys. But At least two. I'm going by memory. So I mean, I don't see. People keep saying, oh, well, this, like you said, that this is a weak case, but Atlanta's stronger, or Fulton County's stronger, and then the Fed's stronger yet. Well, first of all, the credibility of those cases is undermined by how ludicrous this case is. Secondly, I don't think so. I don't think those cases are particularly strong on obstruction, not in Fulton County. And as one of Trump's lawyers was on Meet the Press over the weekend, James Trusty, saying, look, that all they're trying to do is create separation from the Biden case so they can find a way in on the Trump case. But that doesn't make the case on the merits and the legal merits a strong one. It just makes their political calculation more complicated when it comes to the federal case and classified documents.
No, the federal case is not strong by any means. It's actually a very weak case, and the special prosecutor is not going to bring charges there. So everyone should just back off and relax about that. You're not going to see anything. The Atlanta case, whether you believe it's strong or not, it's stronger than the Manhattan case. There are more witnesses, and there are more serious offenses that are alleged to have happened. So if you want to rank them, the federal case, you can more or less ignore it. It's not going anywhere. The Manhattan case, highly politicized, highly technical. No ordinary prosecutor within the normal range would bother bringing it. The Atlanta case, there's more going on there. There are more moving parts, and the alleged conduct is more serious. That's the one to keep an eye on to see where it ends up.
All right.
Now, one thing I will say is we always have, all prosecutors are supposed to know that you're not supposed to do things during an election season. DOJ actually had a pretty strict rule that you had to cut off prosecutorial conduct, public conduct, once you got too close to an election. So the Fulton County prosecutor, Fonnie Willis, should take that into account, and she should make any decisions she's going to make by about July 4th of this year.
Well, here we go again with all of those great protectors of our representative republic's norms violating the norms to get Trump. So one of the other rich ironies about the Trump era. Tom Hoagn served as federal prosecutor, local prosecutor, and elected DA. He's currently in private practice. Tom, thanks as always. Appreciate it.
Absolutely. Take care, you guys.
Thank you. And he joined us on our turnkey.pro answer line.
It's what Chicago is talking about. It's Chicago's Morning Answer with Dan and Amy on AM 560. The Answer.
This is Ed Morrissey of HotAir.com for Town Hall. For years, Twitter pushed back on complaints, primarily from the right, about suspected shadow banning. Executives, including founder Jack Dorsey, repeatedly insisted in congressional testimony that no such practice took place. Now, Elon Musk has released Twitter's algorithm, and we know the truth. Twitter built its code to suppress comments based on complaints, blocks, and mutes, punishing users far more for such feedback than for likes and engagement. Twitter engineered its algorithm to incentivize block lists and complaint campaigns, both of which